Welcome to this episode of Consortio Law Firm Series, Legal Strategies Unlocked, our team in action. Today, we're going to explore a real-world situation where some really sharp legal thinking helped our client navigate a pretty complex business disagreement.
That's right. And the scenario we're looking at, it started off seeming quite standard, a regular commercial relationship.
Right.
Our client, let's call them Company B, that they work in industrial technology, production supplies, that sort of thing, had this ongoing supply agreement with another company, Company A.
Okay.
Now, interestingly, Company actually sued Company B first. But the real focus for us today, the heart of the matter, is Company B's strategic response. They filed a really well-crafted counterclaim.
And that's exactly what we're going to unpack. We've got the legal documents for Company B's counterclaim, and the goal here is to really understand the legal arguments, the facts on the ground that let Consortio Law Firm represent Company B so effectively. You shared these docs, so let's get into it.
Absolutely. To really get why this counterclaim was so effective, we need to back up a bit, see how it all began.
Makes sense.
So Company A and Company B, they had this established business relationship, supplying industrial goods. Company A sent over several purchase orders.
And Company B accepted some of them. I see one mentioned specifically in the filings, order number 11.
Correct. Order 11 was accepted, and Company B fulfilled it. They sent out an invoice dated September 15th, 2022. And importantly, someone from Company A actually signed for the goods, proof of receipt.
Okay, so goods delivered, invoice sent, proof of receipt signed. Seems straightforward enough so far. What happened with payment?
Well, Company A tried to pay. They issued a check dated October 16th, 2022. It was for a substantial amount, 410,400 Egyptian pounds, drawn on a major bank.
Right.
Company B deposits the check, but here's the first snag. The signature wasn't right. Invalid signature.
Oh, okay. So maybe just an admin error, something that could be fixed easily.
You'd think so.
Yeah.
And Company A did issue a replacement check, but the second one, it hit a bigger wall.
Yeah. Rejected. Insufficient funds.
Oof. Okay, that's not just an admin error anymore. That's serious. How did Company B react?
Understandably, they took it seriously. They actually filed a police report about the bad check.
Right.
And that led to a formal legal case against the representative from Company A who issued it.
And what came out of that? Did the court make a finding?
It did. On January 9th, 2023, the court found Company A's representative responsible for, issuing a check without the funds to back it up. The person was actually sentenced in absentia.
Wow. So there's a legal ruling confirming the check was bad. Surely that resolved the payment issue then.
You would think so, wouldn't you? But no. Despite that ruling, Company A still didn't pay the outstanding amount for those goods.
Still no money, even after the court ruling. So Company B has this finding, but they're still out of pocket. What did they try next?
They moved to the civil side of things. First, they tried to get a summary judgment, basically asking the court for a quick ruling since, the facts seemed pretty clear.
But that request was rejected. So next step, they filed a direct lawsuit in the commercial court.
Okay, so a full lawsuit now. And this is where things got even more complicated, right?
Exactly. In that lawsuit, Company A came back with a pretty significant defense. They argued that Company B had waited too long to sue over the check itself.
How so?
They invoked the statute of limitations. It's basically a legal deadline for filing certain types of lawsuits. For things like checks negotiable instruments, there's often a shorter time frame, like 1 year, to encourage quick resolution.
Oh, okay.
Company A argued that under the commercial code, that 1 year deadline had passed since the check was issued or due.
And did the court buy that argument?
Unfortunately for Company B at that stage, yes. On October 29th, 2024, the court ruled for Company A. It dismissed Company B's claim specifically because of that statute of limitations. It looked like a dead end.
Right, so let me recap. Company B delivers goods, gets a bad check, gets a ruling about the bad check, tries to sue for the money, but loses because they supposedly missed the deadline related only to the check itself. This feels like the point where Consortio Law Firm stepped in with that counterclaim strategy we mentioned earlier.
That is precisely the turning point. Despite losing their own case on that technicality, Consortio, representing Company B, didn't just, pack up. They looked at the original lawsuit, the one Company A had started against Company B earlier, Case 4-2025.
Ah, the case Company A initiated first.
Yes. And within that ongoing case, on March 24, 2025, Consortio filed the strategic counterclaim. The goal wasn't just the original 410,400 pounds, but also damages for everything Company B had been put through.
Using the opponent's lawsuit as the vehicle for their own claims. That's clever. So what was the legal basis? If the direct claim on the check was out due to the time limit, how did they structure the counterclaim?
Great question. They couldn't rely on the check as a check, if that makes sense. So they built the counterclaim on several other strong legal pillars. The main one, unjust enrichment.
Unjust enrichment. Explain that a bit.
Sure. The core idea is simple fairness, really. Even if the specific legal action on the check was time-barred, Company A had still received valuable goods, the industrial supplies, and hadn't paid. They were therefore unjustly enriched at Company B's expense.
Right. They got the benefit without the cost.
Exactly. And crucially, the commercial code itself has a provision, Article 532, that specifically allows the holder of a stale check, one past its limitation period, to sue the issuer based on this principle of unjust enrichment. We back this up with established case law from higher courts, too.
Okay, so the law anticipates this kind of situation, where the check itself might be technically out of date as a claim, but the underlying debt and benefit received still matter.
Precisely. It prevents someone from hiding behind a technicality to avoid paying for something they received.
That makes a lot of sense. What was the next part of the counterclaim strategy?
The second pillar was legal interest. Consortio argued Company B was owed interest on that principal amount, the £410,400, and not just from when they filed the counterclaim, but going all the way back to the check's original due date, October 16th, 2022.
Why from the due date?
We pointed to the commercial code again. Article 64 says interest on commercial debt starts accruing from the date the debt is actually due, not necessarily when you file a lawsuit. Plus, we use the civil code too, arguing that since these were commercial goods likely generating revenue for Company A, interest was owed from delivery.
So they were claiming compensation for the time value of that money being withheld for so long. Makes sense, especially with inflation over that period. What else?
Third, we claimed material damages. This was broader. We argued for compensation covering all the direct harm Company B suffered because of Company A's actions.
Like what specifically?
Well, the obvious failure to pay, the whole bounce check fiasco, the costs Company B incurred chasing the debt through the police and courts. And importantly, the real financial impact of not having that significant amount of working capital, especially given how much prices had increased in the industrial sector since 2022. We cited civil code articles about liability for wrongful acts and acting in bad faith.
So not just the debt, but the knock-on effect.
Exactly. And we tied this into their whole business relationship. We invoked Article 117 of the Commercial Code, arguing that Company A's failure on this one supply order was such a breach of trust that it justified terminating the entire ongoing supply agreement between them. This breach caused significant damage and loss of faith.
Wow. Okay, so this single unpaid invoice could potentially unravel their whole supply relationship and lead to damages for that disruption, too.
That was the argument, yes. Which leads to the fourth point, forfeiture of a down payment. It seems there was another related order, Order 26, possibly linked to Order 11, where Company A had paid a deposit but not the full amount.
Another order involved.
Yes, or at least a deposit related to the overall transaction. Consortio argued that because Company A failed to complete their payment obligations for Order 11, they should forfeit the deposit they'd paid, over £91,000.
How does that work legally?
We cited Article 103 of the Civil Code. It basically says a deposit or down payment can act like an earnest. It gives either party the option to back out, but the party that withdraws, or in this case fails to fulfill their side, forfeits that deposit.
So because Company A didn't pay the rest for Order 11, they lose the deposit they already put down. Interesting angle.
It is. And then fifth, flowing from the breach of trust argument, was the formal request to terminate the periodic supply agreement. Citing Article 117 of the Commercial Code again, we asked the court to formally end the whole ongoing business relationship due to Company A's unreliability and failure to meet its obligations.
Seems like the trust was completely gone by then.
Completely. And finally, almost as a safety net, Consortio included a sixth argument, set-off.
A backup plan.
Sort of. It was a contingency. If, for some reason, the court didn't agree with the deposit forfeiture, Consortio asked for a legal set-off. Basically, if Company B happened to owe any small amount to Company A for some other reason, that amount should be legally canceled out against the much, much larger debt Company A owed to Company B.
Got it. So ensuring that the big debt owed by A wouldn't be reduced by some unrelated minor claim against B. That is a very thorough counterclaim.
It was designed to be comprehensive, and there was one final, quite clever point Consortio raised.
Oh.
Remember how Company A's defense in the earlier lawsuit was the statute of limitations on the check?
Yeah, the time limit argument.
Well, Consortio argued that by even making that argument, Company A was implicitly admitting the underlying debt existed.
How so?
Think about it. You can't argue that the time limit has expired on an obligation you claim never existed in the first place, right?
That's a good point. You have to acknowledge the debt exists to argue it's too late to collect it.
Precisely. It's a subtle but powerful point, supported by evidence law principles. It showed Company A was trying to use a technicality to avoid a debt they knew they owed.
This whole case is a fantastic example of how, even when things look bleak, strategic legal thinking can really turn the tables. That counterclaim, hitting on unjust enrichment, interest, damages, forfeiture, termination, it really covered all the bases.
It really did. It shows how you have to look beyond the initial setback and understand the full range of legal principles available, commercial law, civil law, evidence law, to protect your client's interests proactively.
And it highlights that fundamental fairness principle, doesn't it? The idea of unjust enrichment preventing someone from just keeping goods they didn't pay for, even if the initial payment method, the check, hit a technical snag like a time limit.
Absolutely. The law provides these mechanisms to prevent unfair outcomes. It's not always just about the narrowest interpretation of one rule. It's about the broader context and preventing parties from benefiting wrongly.
Plus, considering the termination of the whole relationship and damages for that disruption, it really underscores that a breach in one area can have much wider consequences in business dealings.
Definitely. It's a reminder of the importance of trust and fulfilling obligations in ongoing commercial relationships.
Well, we hope this look into Consortio law firm's work has given everyone listening some valuable insights into the complexities you can face in commercial disputes and how strategic legal tools can be used. It certainly makes you think differently about how legal arguments can be deployed. What part of this case stood out most to you? Or what other kinds of business disagreements make you curious about the hidden legal strategies? This was just one example from our series, Legal Strategies Unlocked, our team in action, aiming to shed light on these real-world legal challenges.